How's it going, everybody? In this video, I have an update for you on the Franklin Armory Title One case that is currently going in the state of California. So let's talk about this. But real quick, before we jump into this video, if you think the state of California needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, and that is Route 66 Shooting Sports Park in San Bernardino. We recently had the Armed in May event out there, and the staff is absolutely amazing. The range is absolutely amazing. So if you guys are in the Southern California area, if you're in the LA area, I highly recommend you guys take a look at them. And thank you, Route 66, for supporting this channel. I also want to give a shout out to USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you guys are in the market for something like that, if you guys carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. So like I said in the intro, I have a quick update for you guys on the Franklin Armory Title One lawsuit that is going right now in the state of California. So the Franklin Armory Title One is a firearm that was created by Franklin Armory. They were a past sponsor of the channel, like a lot of you guys know, but they created this product specifically because of California's laws, like California Penal Code 30515, that bans specific types of firearms configured in specific ways because the California state deems them to be so-called assault weapons. So the Title One was created, it was produced by Franklin Armory, and then was intended to be sold to residents like me and you in the state of California. And the California Department of Justice acknowledged that this did not violate any of California's laws. But what the California Department of Justice failed to do is to add a classification in their DRO's drop-down menu. The classification would have been other, and that's why a lot of people called the Title One an other. They wouldn't add that classification in their drop-down menu. They told Franklin Armory on multiple occasions that they were going to add that classification into their drop-down menu, but just failed to ever do it because they didn't want these types of firearms to be sold in the state of California. They drug their feet, they never did it. And ultimately what that did is it barred Franklin Armory from being able to sell those products to California residents. In the meantime, the California legislature worked hard to actually change and amend California Penal Code 30515 in a way that the definition would be changed, amended, so that the Title One would be included in that definition of what California deems to be a so-called assault weapon. And that's exactly what they did. Last year, they quickly pushed through SB 118. They copy and pasted language from a prior bill into SB 118 and then pushed it through real quick on a vote. It was passed, and then all of a sudden, the Title One is now considered to be an assault weapon in the state of California under the California definitions. And actually, there is going to now be a registration requirement for anyone who purchased the Title One or is in possession of a Title One or other configuration or equivalent. That there's going to have to be a registration of those firearms, similar to how other so-called assault weapons had to be registered in the state of California. And that deadline is if you lawfully possess the weapon prior to September 1st, 2020. So that's when you had to be in possession of that item. And then you have to register the weapon by January 1st of 2022. So that registration period is coming up here soon. Now, because of all these shenanigans, essentially what happened is Franklin Armory sued the state of California and the Department of Justice, and that is the case we're talking about here. And so my last video was talking about how this case was kind of on hold for a while because there was a demur and the courts were deciding whether or not they were going to grant the state of California's demur or not. Ultimately, they denied the state of California's demur, and now this case is moving towards trial. And we got an update that essentially Franklin Armory has requested judicial notice on two cases that actually went the way of Second Amendment rights. That was the Sharp v. Becerra case and also the Miller case. So they're requesting that the court take judicial notice of these two cases and take a look at them and use them in actually reaching their determination here in this case. If you're not familiar, the Sharp v. Becerra case was an FBC-driven case against the state of California based on their failed registration processes back in 2018 when the whole bullet button assault weapon registration happened and you had to register those bullet button assault weapons with the state of California. Ultimately, what happened is the state of California absolutely botched the system. Their website did not work, so a lot of individuals tried to register their so-called assault weapons with the state of California, but couldn't because the website just didn't work. So this left a lot of people maybe potentially being felons and violating California's laws. So there was a lawsuit against the state of California based on their failed procedures and their failed website kind of back-end stuff or issues that they were having. Ultimately, the Sharp v. Becerra case was reached in a settlement. There was a settlement reached, and the state of California essentially admitted that they failed to properly institute the registration, that they had issues, and then they reopened that registration deadline. And we talked about this on the channel prior. Now, they also requested that the court take notice of the recent Miller v. Bonta case or the Miller v. Becerra case. And this had to do with actually the whole language here, 30515, and California's actual ban on so-called assault weapons. If you're not familiar, Southern District Judge Roger T. Benitez in the Southern District of California recently issued an order in the Miller case finding that California's ban on so-called assault weapons was indeed unconstitutional. And this led to a huge uproar, not only in the state of California, but nationwide. This was picked up by a lot of news sources, pretty much bashing Judge Benitez for his ruling. But a lot of us here in the state of California were very happy with his ruling, and he's given pro 2A rulings in the past. As of right now, that Miller case is on hold. It was appealed up to the Ninth Circuit. The Ninth Circuit is going to take that appeal, but also they stayed Judge Benitez's ruling until the Duncan v. Becerra case is actually heard by an en banc panel. The en banc panel has heard those oral arguments, and we're just waiting for a decision there. But right now in the Ninth Circuit, there's a whole other issue, which I've talked about on other videos, where everything's kind of backlogged. But the Miller case did go our way, and we had a Southern District judge find that this specific law, Penal Code 30515, which was amended to include the Title One, he found that that language was indeed unconstitutional. So why are these two cases relevant in this Franklin Armory case, and why is there a judicial notice on these two cases? So I'll read actually from the judicial notice right here. So in regards to Sharp, it states that this is relevant here because technical difficulties are also what prevented petitioners, customers, and members from completing the purchase of their centerfire Title Ones before SB 118 took effect. And Sharp shows that there is precedent for the DOJ reopening the assault weapon registry to correct its own prior errors. So they're saying Sharp is relevant because Sharp dealt with the failures of the DOJ when it came to the assault weapon registration back in 2018. Here, similarly, in the Franklin Armory issue, there is a failure on the part of the DOJ to actually add that drop down of an other so that Franklin Armory could sell those firearms to us California residents. And they couldn't do that because the DOJ failed to actually institute this procedure. Similar to how they did in Sharp, now they have done it as well in this Franklin case. And so they're saying, hey, they reached a settlement. The state of California acknowledged they had issues in Sharp, and here that's super relevant because that's what's going on in the whole Franklin Armory Title One issue. Now, when it comes to Miller, what they state is, as for the decision and judgment in Miller, their relevance is more straightforward. Petitioner's mandamus claim as to centerfire Title I is, and at least partially rooted in the argument that California's assault weapons ban, as far as it is concerned to centerfire Title I's, is unconstitutional. So the argument here is pretty straightforward. What they're saying is you've treated the prior language in 30515 as unconstitutional in Judge Benitez's order in Miller. Similar here, the whole regulation of the Title I as a banned item, again, unconstitutional, violates the Second Amendment rights, and you need to look at Miller and that decision there to reach your determination here in this Franklin Armory case. Now, one of the reasons why I want to bring this to your guys' attention, why I thought this is important, is because when I've made prior videos like on Sharp and Miller, a lot of people said, yeah, these are good wins, but they're not going to amount to much. But like you can see here in this judicial notice in the Franklin Armory Title I case, these cases are actually being used in other cases. So we're having a downstream effect as far as these positive 2A rulings in Miller, in Sharp, and all these other cases. They are now being pointed to in subsequent cases as actual precedent, as actual guideposts for other courts to follow. And that's huge because, again, in the whole Miller issue, we've never had a court, a federal court, actually say that a law like this, a ban on so-called assault weapons, is indeed unconstitutional. And now you have another case pointing to that decision saying, hey, look what they said. This deals with similar issues with the Franklin Armory Title I, and you need to follow what Judge Benitez said. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you guys like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm. It helps to signal to YouTube that you guys see value in these videos, in this type of 2A news, and then it pushes it to more individuals. So even if you guys don't have anything directly that you want to comment, even just commenting, hey, I'm just commenting to fuel the algorithm, that really helps the video. It helps push it to more individuals, and I really appreciate it. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this station was built by Arm Scholars, and this station will be maintained by Arm Scholars.